Hi, I'm Lawrence Gund of the Kann California Defense Group. Today I'm going to talk about criminal threats, which is covered under California Penal Code 422. Now, criminal threat is defined as willfully threatening to commit a crime which will result in death or great bodily injury to another person with the specific intent that the threat, which can be made verbally, by written means or electronic means, be taken as a threat, even if there is no actual intent to carry it out. What that means essentially is what the crime requires, other than making the threat to another person that would again result in significant bodily injury or death to them, is that it be made by either verbal means, written on a note, or by electronic means such as text message, email, posting on their Facebook wall, any Snapchat, any sort of social media application would also qualify. It also doesn't have to be made directly to that person. It can be a criminal threat if you tell a third party that you're going to hurt somebody else, and that message is conveyed to them. So if you tell Joe, hey, when Fred gets out of work tomorrow, I'm going to beat the hell out of him, and Joe conveys that message to Fred, well then Fred has been criminally threatened. Also, it's important to know that there doesn't have to be the intent to carry out the threat. So for example, a police officer's asking you, hey, did you make this criminal threat? And you tell him, well, no, officer, I didn't do that, because even though, yeah, I threatened him, I said I was going to beat him up, I was never really going to do that. I just was really angry at him, and I wanted to scare him and make him think I was going to. Well, if that's what you tell the officer, you've just admitted to making a criminal threat, because it's not required that you actually intended to do it. It's just required that you actually intended to instill fear in that person that you were going to do it, and you had some reasonable ability to carry it out. Now, there are a number of defenses to making a criminal threat. One is that it was too ambiguous or vague. Say, for example, you just are angry at a person, you say, hey, one of these days I'm going to get you. Well, there's no specificity there as to what you're going to do. There's no time frame within which you're going to do it. For a criminal threat to be valid, it has to invoke a fear of some reasonable, immediate harm to that person. And something like that would just be too vague to really qualify as a criminal threat. Another one is if the fear is unreasonable under the circumstances. Let's say, for example, that a person who's in prison, they have a lifetime sentence to prison, gives a call to his lawyer in that case, and he's angry and he says, hey, when I get out of here, I'm going to kill you. Well, if that person truly is in prison for the rest of their life with no possibility of parole or ever getting out, that would not be, the lawyer couldn't really say that they were in reasonable fear of that person, because they have no ability to carry that out. Another situation which would be a valid defense is if the person was not actually afraid. Let's say a couple guys are hanging out at a bar. One is a 6-foot-tall martial arts expert, and the other person is half his size. He's drunk out of his mind, and he says, hey, when I get out of here, when we leave this bar tonight, I'm going to beat the hell out of you. The martial arts expert just looks at him and laughs and finishes his beer and goes on his way. Well, in that case, it wouldn't be a valid criminal threat, because the person wasn't actually afraid of this person. It didn't seem to have any real reason to be afraid of that person. Another situation which would be a defense is if the fear was not sustained for any real length of time, if the length of time was negligible. Say, for example, let's go back to the bar and say that person stares a guy in the face and says, when you leave this place, I'm going to stab you. And then 1 second later says, hey, I'm just screwing around with you. I was just practicing for my acting class I've got tonight. And they share a beer together and go on their way. Well, in that case, the fear was not sustained for any reasonable length of time, and that would not constitute a valid criminal threat either. And the final defense to a criminal threat is if it was not conveyed either verbally or by written means or by any sort of electronic means. Say a person just shakes their fist at somebody or just stares at them for a few seconds in a weird way. Well, that really is it's not conveyed in any of the prescribed ways, and it's also probably qualifies as being too vague to qualify as a criminal threat. So if you or anyone you know is charged with having made criminal threats, please give us a call at the Kann California Defense Group. We'd be very happy to discuss with you how we might be able to get your charge either reduced or possibly even dismissed.